Y'all know what it is. Hey, everybody, and welcome back to Eggs. Today's special guest is senior partner at law firm Kilpatrick Townsend Stockton and founder of Triangle IP, Thomas Franklin. As a partner at Kilpatrick Townsend, Thomas focuses his practice on aggressive patent prosecution and strategic portfolio management for high-tech companies. He is also a subject matter expert in the broad spectrum of technology, including computer engineering, networking, software, semiconductors, blockchain, and more. Wisely, Thomas has combined his passion for patent protection and litigation along with his technical know-how to create Triangle IP, an online patent management software that helps enterprise clients capture company-wide innovation. His software helps users manage the patent lifecycle from conception to filing using patent data analytics and other innovative tools. Joining the show today for an insightful conversation about building a patent strategy in your organization to take it to the next level in terms of investment and revenue growth, please welcome to Eggs, senior partner at Kilpatrick Townsend Stockton and founder of Triangle IP, Thomas Franklin. Hey, Thomas, how are you, man?
Very good, very good.
Excellent. Thanks so much for making the time to do this. I think this is a conversation that will apply, I think, to many of the entrepreneurs who listen to this show. And honestly, I don't know that we've had any other sort of patent experts on. So this will actually be a really good conversation for them.
Yeah. So tell us a little bit about yourself, how you got started, where you went to school, and what got you into this field.
Yeah. So been working in the field 23, 24 years, coming up on a quarter century. But kind of my journey started where I studied electrical engineering. I grew up in San Diego. And people talk about bad job markets. Well, to put some perspective on it, I was graduating with no experience into a market that had just seen the Cold War ending, right? So the big employer in town, General Dynamics, big defense contractor, laid off 40,000 engineers into a market that had 1 million people. So if you go through the math, about 1 in 20 people was a laid off engineer with experience, right? So people talk about bad job markets, but that was the worst. And almost everybody that's become a patent attorney, it was a plan B. Like plan A was, go out, be an engineer, have a lot of fun building stuff, and absolutely loved engineering. I did it for 8 years, but then started going to law school at night because it was just a really dark time. Probably I should have just moved up to the Bay Area. I'd probably be retired by now. That was the key time to be in there when valuations were really low. And some of my colleagues did do that, but I didn't make the jump, went to law school at night and never looked back.
Nice.
Yeah, I love that. No, I think it's an interesting thing that you would say that patent litigation is sort of like a plan B for a lot of people, just because it's so wildly important, especially now in sort of a technical world where people and their innovations are basically they're building companies off of somebody's innovation. It seems like maybe more than ever, and maybe always, but now more than ever, at least publicly, patent protection is obviously a very critical aspect of law these days. So now, even though it was your plan B, what does your practice look like, and how do you, what do we do with a patent attorney, or when do we engage one?
Yeah. So, I started practicing at a big law firm and got some experience. And what I found was often there was a disconnect between the objectives of a particular enterprise and what they wanted to accomplish with IP, because you're very right. People don't understand it. They may have some sort of motivation. Somebody on the board said we need to get patents. Well, what kind of patents do you need? How many do you need? Where do you need them? So I kind of started applying kind of some of these engineering principles that I had learned to this process and kind of game theory to say, it's not one size fits all. And I found too much of the strategy in my industry was when you were asked the question, how many patents should I file? It was like, how many can you afford, right? Because we want to get paid was kind of the strategy or the extent of the strategy. Nobody really knew. So how do you get a better idea of what makes sense, what's affordable, what's the end goal, what's the exit strategy, looking at all these things. And I became within the firm either for big companies, kind of the turnaround expert is pulling apart why they were filing patents and seeing if it made sense, sometimes abandoning a bunch of them, sometimes focusing in on a different area, and certainly doing that for the startup companies. So it was very important for the startup companies.
So patents are one of those things that they go over a lot of people's heads. A lot of people don't even realize they need them or when they should get them. Can you kind of give us an overview of what the process looks like and when someone actually needs to apply for a patent and go down that road? Because I know it's not cheap and it's definitely not easy. That's for sure.
Well, and before you get started, I just wanted to pile on to Mike's question too, and just have you sort of maybe give us like a broad definition of IP. I think we're throwing it around like people know what we're talking about, but we probably should lead with a definition.
Yeah, and there are different definitions, but I'm going to stick with the legal stuff, right? The things where you would go to a lawyer and ask for their help. But intellectual property is the way that you can legally protect intangible assets, ideas, right? An idea is not protectable. You might have a great idea, you talk to a bunch of people, you can't own it unless you go through some of these legal hoops to protect it. So I may just be talking at a bar about something that I'm up to. Somebody overhears me, they can run with the idea. Well, I shouldn't be doing that if it's something you want to build a business around. You might have somebody sign a non-disclosure agreement, an NDA. And then there you have a legal construct around their intellectual property construct of a trade secret. And if they've signed something, you also have a contract right. So what the lawyers will do is they'll take these ideas that are kind of amorphous, they're in the cloud, nobody can own them, and they'll put boxes around them. And the boxes are these legal tools to protect them so that they can become property, intellectual property. Because before it's property, it's nothing, it's just up for grabs, right? But when you're building a business, it's especially important that you create property because that creates shareholder value. And that's how you see companies like an Apple, for example, with no factories. They have a campus, a beautiful campus, I hear. They come up with a lot of things, a lot of ideas, but they're very dogged about protecting those ideas with intellectual property. And that's why you see them as one of the most valuable companies on earth, yet they don't own any of the normal things that traditionally in the industrial age you would see as important to creating value for a company. It would be factories, it would be property, equipment. They have none of that. They have brilliant people and a scheme to protect what they come up with, these ideas, so that they can own them, and hence the stock becomes worth a tremendous amount of money.
Okay.
Now, I've heard of little tricks you can do to kind of like do it yourself kind of thing, like write your idea down, put it in an envelope, seal it with a date, and put it in a safe. Does that hold any ground, or is that just hogwash?
Yeah, so that one's urban legend.
Yeah.
There are certain things that you can do, right? You can file your own patent, you can file your own copyright. With a lot of this stuff, even though you can do it, just like you can defend yourself in court, and what's the expression is, the person that defends himself in court has a fool for a lawyer, right? Because they're their own lawyer. So it's the same sort of thing where this is the information age, and what you're coming to me for is you're coming to me for this knowledge. And that's what I'm selling, is this knowledge, even though absolutely correct, is you can represent yourself, whether you're a fool or not. I'm very flexible. Is what I try and find with the client is what skills do they have, what skills do they not have. I appreciate that I'm very expensive and I charge per hour, but I just want to kind of nudge them in the right direction. If they're very good at tracking things, I'll help them set up a system for tracking things. If they're not, look, fly me down. I'm taking a 10-hour flight to see a client tomorrow for a 2-hour meeting, because they're an emerging unicorn and their time is very valuable, and relatively my time is far less valuable in their mind's eye. So I'll sit down with them, I'll take notes, I'll I'll run a recorder. I'll do some of that for them, even though, it's going to be a few $1,000s for them to do that. And I'm happy to do that because for this unicorn opportunity, they really need to have some intellectual property. And they have currently, in current market conditions, unlimited money. It's just a matter of grabbing as much as they can to keep the momentum going so that they can reach unicorn status in the next couple of rounds.
Yeah, no, I think that makes a lot of sense. And, to your point about just any professional service, right? I mean, you can fix your own car or you can hire the mechanic, right? You have to weigh out your time, your value, your knowledge, your ability, et cetera, versus hiring a professional to do that. So I think it's kind of the same case. And I think part of it too is a little bit peace of mind, right? You go to the attorney versus doing it yourself just for the, I guess, confidence that you have somebody in your back field, in the event there's something goes wrong, or if, somebody brings a charge or something down the road, or brings a suit down the road, you have somebody there to sort of watch your back, I guess. One of the other things I wanted to talk about too, just as we're sort of laying out definitions here, is you mentioned copyright or trademark. And I wonder, if we could just sort of delineate the difference between patent, copyright, and trademark and what they're each used for.
Yeah, and I'll follow up with a little bit of talk on the process, right? Because I always think of a timeline. And when I give a presentation, I'll talk about kind of how things evolve. So, and it's a good way to kind of chronologically think about it because, you're starting up a company. When do I do what? And when do I need to start spending money? And what are the pitfalls of waiting? Because often, you would go broke if you hired the best vendors at the earliest possible moment. They will make their money, but you will be out of business. So say you're a startup and, you have to pick a technology area, but I'll pick software because this is where I help out quite a bit. Is you have a problem that needs to be solved. So you're kind of thinking about a particular area. Well, you're going to start to get knowledgeable about it. Hopefully you come to the table with the skill set or access to that market in a unique way. You've done it before. You've been the founder of a company. Maybe in the investment bankers, you can raise money, but you have something to kind of give you a leg up in a particular area. And then you have this problem that needs to be solved. Well, the first thing I would worry about is who has staked their claims. You can think of patents as being landmines where people are protecting a particular area. And there's some areas where there's big entrenched incumbents and they've filed a ton of patents. You may have a great idea to do a new inkjet printer. Well, there's a couple companies there that have really filed a ton of patents. And it would be very unlikely you could break into that area unless you really had something that was 10x better than what happened before. So you might do a landscape study, right? Is what's going on in the patent world? What sort of other things might I need? I had this conversation yesterday where this particular software company, this unicorn, really needed to evangelize in their particular area. So there's copyright issues, right? They had this team that was going to do a documentary and stuff like that. Well, try and avoid other people's copyrights. And people will often get onto websites where you can download an image or a little video clip and it's free. Well, often it's free, non-commercial use. Well, you're making your own video. So really knowing that, and I got convinced that the producers they had hired were very cognizant of that, and they were kind of so worry about other people's rights first, because you may be getting into an area and you may think, this is, I'm all in on this idea. This is amazing. What I find is innovators have an affliction, right? Is they see problems and they want to solve them. And not everybody's that way. They're just like, yeah, there's a problem. I'll take a left turn here. But an innovator's like, well, that's a pothole. I can fix the pothole. I can fix the road. They start thinking along those lines. So you're going to have a bunch of great ideas. And some of them are going to be bad ideas. So for these early stage folks is you want to do an evaluation. Maybe you could think of it as due diligence. I think of it as kind of landscape, getting the lay of the land, seeing who's there, who you're likely to be fighting with down the line. And you can find that it's a dead end. You may have a great idea, but as it turns out, there's no way to get it developed with your resources. And I think being pragmatic about that is important, because I've seen serial entrepreneurs where they have 2 or 3 good ideas in a particular space, and then all of a sudden they do a business that's completely different. They have no idea how that business works. They have no relationships. There's somebody with a ton of patents in that area, or they need to get access to people's copyrighted material to make it work. And these are just impediments that can't be overcome. So you want to look at that when you're thinking of all the problems, that you can stack up, is you got to look at that layer that is intellectual property and say, look, can I get the rights to do it? Be it the patent rights, maybe access to the copyrights, maybe some of the know-how that's required in that space. Can I build a factory? Because it's really hard to start in a completely new area and be successful, because there are so many landmines that you're just not aware of. So starting out by looking around.
Yeah, I think that's a really good idea. One thing I wonder, though, is so for a lot of entrepreneurs, especially people just starting a business, like you said, they have identified some problem that they want to pursue and they want to try and fix it. Well, if there are other people in the space, I don't know, at some point, do you discover that, I don't know, HP has bought up all the inkjet patents and there's no future for you and you just need to abandon ship? Is that a decision that a young entrepreneur should be making? Or is there a way to sort of, I guess, proceed and run your business, but, I guess take your approach at this new business or whatever, but are you just opening yourself up to liability in the future?
Yeah, so there's a few ways to go about doing it. People will pivot and they'll just kind of pachinko around like a pinball and get to the right area as they're pivoting. And, the biggest asset that a small company has, or an individual, is the nimbleness, because these large companies are not nimble. So if you can be nimble, you might find that your business is considerably different than where you started, because you keep getting that input and you run up against a roadblock and you back off and you go in another direction. So certainly you can do that. But there are some areas where it just look at something different. And I'll do these studies for folks pretty inexpensively. Like I have clients in the pet product space. It's an area where you can come up with a great idea and you can often get that produced and be in the marketplace pretty easily. And people love their pets and they're always thinking about problems and so forth. There are certain areas, I found one company had a particular configuration of a brush for brushing the hair out of your dog and kind of getting all that hair that might end up somewhere. They had like 50 patents in that space. And this client that I was counseling, who has products, they have products in many different areas. It's just like, look, move on. Just don't come up with a product there. Mental note, patents are expiring in 5 years. Maybe we'll make another run at it. But you're buying a lawsuit because not only do they have a bunch of patents, they're very litigious and they sue everybody that enters that space. Or no, right? Like I did early representation for Nest Labs with their thermostats before they were a unicorn. And look, everybody that gets into that space gets sued by Honeywell. It just happens. And that's why you look at your thermostat and it looks like it was designed in the 50s somewhere in Russia. And there's been no innovation in that space because they crush everybody that comes in that space. So to break through that, we're going to have a super aggressive patent strategy. And it's just the cost of entry. And know it before you put a lot of money into something and you just end up as roadkill like the last 50 companies that tried.
So how does it work for like international law? I have a friend that he had a really cool idea. He took it to market and got crowdfunding, got it all the way up, went and ordered his product through a manufacturer in China. And the next thing you know, that product is for sale on Alibaba. And everything he's done is kind of like following the right trajectory, but there's no way to really combat that, is there?
Yeah, that's a tough one because there's really been patents take a little while to get, and they go country by country. So patent in the US does not stop somebody from selling it on Alibaba. And there's been efforts. The last administration did some pretty cool things in that regard. Is what was happening in China is they had really favorable shipping rates. So you could start up a business that was selling infringing product, and it was never a container load because you can have a container load of goods seized. But if it's just one envelope, they're not opening every envelope that was coming in. So you could knock somebody off, drop ship directly from China with like crazy rates. Like, I was buying stuff that, there's no way I could return it because the postage back, because they were getting really favorable postal rates, which made sense when China was not the powerhouse that it is today. But some of that has gone away because with patents, and enforcement of patents, it's expensive. So you have to find that container load that's really going to hurt that company that's coming into the US. You get it seized at the border, and there's ways to go about doing that and using those seizure laws to really cause pain. Because when somebody has a container load of $1.5 million worth of product, they're going to take your phone call, and that injunction you got against them, it really matters. But when they're sending a bunch of envelopes, it becomes really tough. And the people that are doing that are often moving around. They have fake addresses and so forth. So you've seen a lot of sites pop up. Alibaba is one of them, but there's a dozen of them that will ship knockoff stuff very quickly. And it becomes difficult. So sometimes you're going to trade shows. I have one client that the big trade show was in Hong Kong, and he showed up with Chinese lawyers ready to start suing people at the trade show and really sending the message that, hey, that you're not going to get away with this. And
Right.
it was pretty effective. It was pretty effective at shutting that down. But it becomes a whack-a-mole problem sometimes under that circumstance for certain products. But anytime there's an aggregated amount, like, it shows up in a big box store, there's a conference, you can then use litigation and threats and stuff like that to try and clamp it down if you can. But that Kickstarter thing, it became a business where people were trying to fast follow. The fast follower is a person that sees your idea and very quickly tries to capitalize on it. And that's where sometimes my advice to them is like, look, figure out a way to make it cheaper. Maybe you wanted to produce it in the US or whatever. Find somebody that's maybe even knocking you off and go and talk to them and say, hey, look, you're producing them really inexpensively. I thought I could have some premium pricing for a while. But nobody can compete with good product, with good branding and good pricing. And maybe you were forced into that pretty quickly, but it is what it is.
So when you have, widget A and, it's an actual tangible product, it's fairly easy to say, all right, it does this, and get your IP in order based off of what it does and what it is. When it comes to software, that's an entirely different animal. Say, for example, LinkedIn versus Facebook, they're both kind of the same product. Does it come down to the actual code that's written in a software application versus the functionality of what the software does? Because the software,
so let me break it down there.
Sure.
So copyright and patents. So the copyright is almost like, you can think of as plagiarism. Is I can look at what your product does and then I write fresh code, not taking any of that code, not downloading it from the website or so forth. And then I don't have a copyright issue. So copyright comes in when there's been some sort of leakage, like an employee leaves and it's like, oh, I coded that up at my last employer. And you're thinking, wow, that's great. I didn't want to spend 3 weeks coding up a web server. Or, open source is a way to kind of get around it, but you got to really follow the rules to leverage that. So copyright is a very narrow thing. It's a sort of thing that just with a little bit of training and a little bit of housekeeping, you shouldn't have issues. Patents cover the functionality of it. So, I'm trying to think how LinkedIn is different from Facebook. So LinkedIn very much looks at your resume versus Facebook doesn't, right? It's looking at other things, affinities in other ways. But LinkedIn, They're always trying to entice you in. It's like, oh, so-and-so got a job promotion. I'm thinking, well, gosh, I want to sell something to, I want them as a client. So they're trying to hook you in a different way. So they're looking at different data, whereas Facebook is like putting something incendiary or something, interesting in front of you to draw you in that way to get that emotional reaction. So if you take those two premises, you would design your system differently. You might be pulling from this database or that database, or gathering different types of information to know that, hey, look, I might be trying to sell to these people. How do you go about doing it? And there are little differences, and you get into those little functional differences. And it's kind of irrelevant whether it's software or you built a machine to do this. It's that functional difference.
Well, and so
function,
to keep using that metaphor of LinkedIn and Facebook, for example, are there parts or aspects of patent filings or things that you might want to patent that just aren't patentable? So let's say in the case of these two, ostensibly, like Mike was saying, they're kind of the same, right? There's a form and you put a post in it and then you submit it and people can like it or celebrate it or whatever they're doing nowadays. But like that bit of functionality is the same on both platforms, right? So yeah, there's some algorithmic differences and things like that. And maybe like, let's say that part's patentable, but maybe putting content in a form and submitting it has become so ubiquitous on the internet that can't be patented any longer.
So I get that question a lot, and I'll just tell you as a layperson, you're going to get it wrong, because people come to me and say, look, I don't think you can patent that. I can dig down a couple layers or think out over the horizon a little bit. It's like, well, you're going to use machine learning next time to make that form autofill. And are you going to maybe adjust the questions? Maybe you're going to have an adaptive form. And what information would you use to have that adaptive form? So typically, maybe what you're working on today or what you did last week, and really you can't patent anything. This is another hard and fast rule, a timing issue. You can't patent anything that you released more than a year ago or talked about publicly more than a year ago. But there's always kind of the tweak you're just about to do, or, and technology has a way of working itself into your system. So you might be putting it on the blockchain or, encrypting it, There's always something that you're doing to enhance it. There's a security threat that you're trying to address. And that's where the patents lie, is these things that you just put into the product or just about to put in the product to solve some underlying issue. We got to screen out payments going to Russia now for whatever reason. How do you know it's going to Russia? And there might be some technology associated with that. So there's always something that the technology people are doing way down deep into the system, not what you're seeing on the screen typically. It's screen stuff that shows up on the screen is really hard to. The patent office just doesn't like certain things, and GUIs they don't like for patents. They want that stuff a few layers down, how you solve some problem to reduce fraud a little bit, or increase convergence, or reduce errors, and everybody's doing that. So the example I use is, who invented the light bulb? It was Edison, right? No, it wasn't actually. It was a Frenchman came up with the two electrodes and burning something in between. Edison had a problem. He was trying to displace the oil lamp, had electricity, accessibility to electricity. So how in the town square do you convert from gas lamps to electricity? You had to put oil in the gas lamp every week. Bulbs only lasted a week, Frenchman. So he went through and he tried 1,200 things in succession, and crazy things like horse's hair. Guess what, genius? I know what happens with hair, and I don't think a horse is any different. So he had no idea, but he sat there and he had one of his engineers in his lab try 1,200 things to find out that carbonized bamboo lasted 6 weeks. And we say Edison invented the light bulb. Well, tiny innovation and a good publicist, and guess what? You invented the internet too, like the 7 people that claim to have done that. So it's really, really slight. Innovation is really, really slight. It's very incremental. And when we write the history books, the difference is a good PR person. That's it. And Edison, luckily, invented the motion picture. And what's better PR than somebody making a movie about it?
Yeah. So I wonder, you mentioned something there earlier that I had never heard before, or didn't know, which was this idea that after you've used something in market or you've spoken out loud, in a public forum about a technology or something, you basically can't patent it after that year has gone by. And I'd not heard that before. And so I wonder if we could just do a little bit of a primer on that kind of thing, right? Because I think, I work in arts and marketing and design. And there's a lot of these, like Mike was saying earlier, putting something in a stamped envelope and that kind of thing. Where it's, implied copyright and when do you actually need to file and all this kind of stuff. So I wonder if there are just sort of some tricks or other things, other rules like that around patenting. Just because if I'm creating a platform, maybe it takes me more than a year to get it done, or maybe, whatever. So like, how do we handle situations where, we've got some innovation that we've been working on for the last 10 years of our life, toiling away, and now we've got it and we want to patent it?
Yeah, so let me kind of break down. There's certain rights you get by creating. So like a copyright, you get certain rights by creating it. And that's where this kind of put it in an envelope sort of thing came up with, is supposedly proof you came up with it first. Rarely, at least in the electronic age, does that become an issue because everything's time-stamped. But at any rate, that was the concept there, is that I wrote the book first because I put it in an envelope, sent it to myself, or I painted the painting, or I did the recording first. So if somebody did it subsequent to that, they must have copied it from me. So that really hasn't been helpful. I haven't seen that become helpful in a long time. And there was some concept of doing that with patents. It was a first to invent system. Alexander Graham Bell and Elijah Gray filed their patent on the same day. And they had a big long litigation to figure out who invented it first. And as was the custom at the time, on Bell's country estate, he demonstrated to a bunch of guests earlier than Elijah Gray that the telephone worked, right? So he is now in the history books as the person that invented and got his patent on the telephone for Elijah Gray, right? And so there was this concept of documenting it that you invented it first. In the US, we switched over to the rest, homogenized with the rest of the world, which is it's a race to the patent office. The person who gets there first is going to be the person who gets the patent. And there is small exceptions to that, but they haven't been successful really at this point. So that's the 99.99% answer, is it's a race to the patent office. So you have this, your own release of the feature or talking about it publicly can count against you. In the US, you have a 1-year grace period from that time to file at the patent office. What they don't want you to do is do something where, like a lot of people want to do this, is they want to work on a product for years and years and years, and after it's super successful, then they want to file the patent on it. And with patents, you've got to do it very speculatively. You've got to do it up front. It's really up front is where you've got to go and try and capture that innovation, unfortunately, which means that it's not a sure thing. You can't wait for it to be successful in the marketplace before you spend the money. But copyrights, you get rights just by creating it. So you might document it, like if you send an email to somebody. I mean, clearly, if it like all gets timestamped. Trademarks, you get rights by using it, right? So in Kroger's this big grocery store chain, and they have in Southern California, they're called Ralph's. And there was somebody that had a little bodega. His name was Ralph. It was Ralph's Corner Store. So when they rolled out in San Diego, they had a problem in that region. Somebody, when you said Ralph's, they thought it was a bodega on the corner. Well, they rebranded as Lucky in Southern California, and then now they're back to Ralph's, because I'm guessing, corner store Ralph got a big check, right? Similar story with McDonald's in the UK. There was somebody last name McDonald that had a pub that was serving hamburgers, right? So it's a first to use and commerce thing with trademarks. Trade secrets is another kind of right. It's when you create something that gives you advantage. It's the formula for Coca-Cola, supposedly, but you can Google it on the internet. Or better manufacturing process or something like that. If you can keep it as a secret and it doesn't get out into the wild, or you quickly try and put it back in the bottle like Apple does quite often, you can keep it as a trade secret and then it's protectable. So I go and talk to you about some new idea I have, I tell you it's a trade secret, and then you go off and do it on your own. There might be a right, especially if there's a contract in place and non-disclosure agreement, to go and sue that person. So those things kind of happen by creation or by doing something. And then typically the lawyer can help you to get enhanced rights. You can register your copyright. You can register your trademark. You can file it overseas. And there's good reasons to do that. Very complex, very quickly. Unless you've got the rest of the day, I'm not going to go into the reasons why you might do that. Patents are different. Patents only are protectable through this government file. And it's a race to the patent office.
Okay. Can I ask just one quick follow-up on that too then? So, I mean, is there such a thing as, I mean, if it's just a race to the patent office, like, I mean, if you see something and some business owner didn't think to go to the patent office first, and they might be in commerce, but you beat them to the office, would that be grounds for not granting a patent, or can you get granted a patent to something somebody else is doing already?
So that inadvertently happens all the time, because I don't know what everybody's doing all over this world. And in a circumstance like that, I mean, you're not allowed to steal somebody's idea. And if you get caught, and typically it'll come out in litigation. It's hard to hide stuff these days with US litigation where you can discover anything. But so taking somebody's idea, kind of not possible. And I'll kind of caveat a little bit. It's almost like first to publish. Because if I can publish and document that I published it and I file within a year, you copying it right after you saw it, because I did a press release, and you copy the idea and file a patent on it, I can always go back to that publication and say, your patent's invalid because I came up with it first. Now, the only way I can get rights is if I follow up with a filing. So often you'll have situations like this, but it's very much, it's got to be documented. Like if you had a conversation and nobody documented it. So I'll give it, for example. I have a client that has a big annual conference. And for a while there, they were flying a bunch of us lawyers up, and we were sitting in hotel rooms, and we would debrief people after they walked the floor. And we'd file those patents that day, right? And to be truthful about this, often it was inspiration. Like they would walk the floor and they had this vexing problem and they saw somebody's booth. They weren't sitting there taking a picture of the booth and we're filing a patent on it. It was like, oh my gosh, I didn't realize you could use blockchain to allow more secure logins. And we've been trying to solve this problem for this product over here. And it was kind of a confluence or taking several building blocks and putting it together. And that's what we were filing the patents. But say you were not ethical and you're just walking the floor, taking pictures of things and filing patents on that. That actually happens a lot in certain countries. Like China's notorious for is, pictures of your product and file it as a patent. Ultimately, it's hard. It'll get figured out in litigation. It was actually very common for them to take your patent that you had filed in the US and them to file it in China. And there were particular reasons about, they weren't as sophisticated as they are today, but they were getting tax breaks as a business to file patents. So why pay somebody to write? We just download them over here, file them over there, and we get a tax break. So there's, that's not going to be a winning argument in almost any court, but nonetheless, invalid patents get issued all the time. And it's just the nature of any sort of bureaucracy is they get it wrong sometimes. But in litigation, that's why they're tremendously expensive to pursue, is they figure all this stuff out generally.
So you started a website. It's triangleip.com to help with people who might need to file patents and move forward with the process. And essentially it tracks the different stages of your patent and then helps them keep them straight. Can you maybe talk about your website and then talk about the actual process of filing a patent and what you need to do in what order?
Sure. And The Triangle IP came out of really a necessity, is I had several big clients that had come to me and said, look, we need to organize our innovation process and we need to be able to track it. And, as much as we like talking to you, you're pretty expensive. Is there a way we can go about this? So over the years, I designed like 10 different systems for clients where they would use a tool that they were familiar with, some sort of workflow tool. So it'd be Jira or Salesforce or some forms. They had to come up with a process to kind of capture their innovation and track it through the system without always relying on outside counsel, lawyers to do it. So after doing it like 10 times and like, it was Groundhog Day, right? It was, the clients were very happy and so forth. I said, look, I got to just build my own system that'll allow you to track the process and engage more richly. And one thing all these platforms didn't have was any sort of deep learning. So here's you want to see a lawyer squirm, patent attorney squirm, ask them how much is it going to cost, right? Nobody wants, what's the likelihood I'm going to succeed? How long is it going to take, right? So imagine me running a restaurant and you come down and say, look, what's on the menu today? I don't know. I got a show at 9:30. Can I get out by 9:30? Yeah, who knows? And generally, what is it going to cost? We don't really have pricing. Can I have prices on the menu? It's going to definitely cost more than that. No one would come to my restaurant, yet I'm in the service industry. So my broad vision is that I think a lot of people, like we started this conversation today, we don't kind of understand it. Well, look, I wouldn't understand how to get food at a restaurant if I wasn't given a little bit more information. Another analogy I'll use is a stock market. Nobody actually engaged in the stock market like they do today 30 years ago, 40 years ago. As you called up a stockbroker and got him on the phone, can you do a trade? It was very cryptic and nobody really knew how to do it. Today, you can download an app. My daughter did this and she's on Robinhood and she's trading stuff, right? So I think there's a similar thing that can happen in the patent space. Like if more people understood it and was more approachable and the costs were somewhat predictable and the timing was so much predictable, you'd have a lot more people engaging in it, like you do with the stock market today, or what AOL did to the internet. There's been these kind of technologies that democratized something that's very, very complex. So rather than hiring somebody very expensive like me or the equivalent internally, you ought to be able to have a piece of software that just gives you the basics: cost, time, likelihood of success. And you want to see a lawyer squirm, you ask him those questions, and you're just going to see some verbal dancing around, So that's what we're trying to do with the tool. Is very early on, there's typically a capture process, patent mining, talking through what the ideas are. So a very, very simple form to capture the idea. But immediately, we're going to tell you, this is what we think it's going to cost. This is what we think your likelihood of success is. Because what do lawyers love? Determined clients with hopeless causes, right? Because I charge by the hour, right? So the likelihood of success. And in my practice, I was doing this, right? And that's why I have a very loyal client base on the legal services side. It's clients that I've had for decades, because nobody gives these answers. And sometimes it's the answer the client doesn't want to hear. But it's just like, look, I'd rather take the beating now versus you spending $1 million and me losing you as a client. So giving those answers to everyone, not just the people that are can afford to hire me at a large law firm, give you those answers so you can make intelligent decisions. So you capture the idea. There's typically a vetting process that goes on. A large company will have a patent committee of people that will consider it. And at some point, you ask outside counsel to work on it, and they'll draft it, and then it gets on file. And then how do you get status? Well, it's pending to the patent office. And how do you explain that? Identify cases that are going good and cases that are going bad. Because kind of my practice has evolved to be kind of this plumber. I go in and I fix things. and I fix really bad things. So, I had one client that came to me, one of the largest software companies in the world, and they hired us and were insistent that me and my team work on it because we found cases that had been argued like 14 times, right? And every round of argument is expensive. And you'd looked it up, you'd spent $75,000 arguing this. And I just picked up the phone and called up the examiner. That's the person at the patent office that's in charge of deciding whether or not to allow my case. And he's like, yeah, I was waiting for somebody. He said, I was waiting for somebody to call because it was just ships crossing in the night, right? Well, it's $5,000 every time those ships cross. So in some sense, I want to do uninspired, perhaps technically competent, probably not actionably malpractice kind of work. Cruise control, right? Is determined clients, hopeless causes, client on cruise control. And I want to give the steering wheel back to the client to say, look, here's what's going on. This examiner typically allows this case in 2 rounds of argument. You're at 14. You got bad counsel, maybe. You got a bad idea, whatever. Pull the plug, put this case out of its misery, and take that $75,000 and apply it to filing 3 more patents.
Yeah, no, I love that. And I think that the idea of simplifying the process, and, I wasn't able to get deep into the software, but from what I could see on the website, it looks like it's very hands-on, drag and drop kind of interface. It looks, very easy to manage these things step by step. And I think you're right. Having this sort of patent analytics, to talk about the ability for success or sort of hedge your bets a little bit, I think is really important. I wanted to talk to you too. We're sort of getting near the end of the show here. And I wanted to talk to you a little bit, just sort of in your expertise as a technology guy and a software guy and a patent guy. And I wanted to talk to you a little bit about blockchain. So I've had ideas, and I'm sure other people have had ideas also, that, maybe with something non-fungible like the blockchain, there might be such a way or such a thing as, I don't know about circumventing copyright, but like that you could almost do like some kind of rights transfer over the blockchain to verify ownership, right? So in the case of our business, our agency, maybe you hire me to do a logo, and then when you pay me, I transfer you an NFT that you can then unlock and pull out your assets or something. And so in that particular instance, I mean, then, I can establish ownership by the fact that it went on the chain this day and all that kind of stuff. Does something like that, or what role, I guess, do you think that kind of technology will play in sort of future patent law? Like what's the future of the USPTO?
Yeah, so the blockchain is tremendous technology, despite the beating that my investments in it have taken.
Yeah, I was gonna say, I don't want to talk about that.
Let's not talk about that. But it's such a fundamental technology, and it's one of those things. It's not the first time we've had a big technology revolution, but it's like such a simple innovation. But what it means is that you're 1,000% certain that the transaction happened with nearly 0 transaction costs. It's immutable in the sense that you can't argue about it. Because a lot of what lawyers do, for example, is just verifying something. Due diligence. Do you own it? Is there any sort of argument that you don't own it? Well, look, if it's on the blockchain, you own it. I mean, there might be a typo in the name or bad data got onto the blockchain, but those controversies go away very quickly so long as the source data is very good. So it's going to make things much more fluid. Like I love your example when it comes to some sort of copyrightable work, but that's what NFTs are. It's a digital right to something. There's no reason why you couldn't take every episode and issue NFTs around it. And that's the best sort of digital rights management you might have. It's a very good application of the technology. So it's going to fundamentally change the way that we go about doing things, because think of something like using a credit card. Why is somebody selling something would I give 2 to 4% to somebody that simply is just saying that's a valid credit card? If it's on the blockchain, that's costs next to nothing to give that same sort of assurance. So a lot of stuff collapses, but the key thing, and I've written lots of patents in this space, some very, very early patents too, is the blockchain is only as good as the source data that went into it, because you could have an error that gets on the blockchain and it's now memorialized, but it's still an error. And you're seeing that even with crypto, where people have been able to get back, stolen cryptocurrency and stuff like that. And that was an error that got onto the blockchain. Somebody stole it, right? And they're using legal methods to get it back. So, but at least there's no argument about what happens in the blockchain. So I'm super bullish on that sort of technology, and it's going to propagate through all industries. Just like something like Velcro was the same sort of way. I mean, you started stitching people up with Velcro instead of, it's one of those things that's going to belie almost everything. And it's going to change a lot. It's like the internet changed a lot. Just like a lot of other things changed a lot. So we're kind of on this hype curve. We're on the upswing of the hype curve, and it's perhaps a really bumpy hype curve, but it's going to be ubiquitous and solve so many problems like authentication and ownership, and so much happens about ownership.
Looks like we might have lost him there for a second.
Yeah. So I think what he was beginning to say was basically that there's, obviously an adoption curve with any kind of new technology. And it does seem that the blockchain is on the upswing, right? I mean, for people who've been following it for some time, especially if you invest in cryptocurrencies or things like that, you've been watching this technology evolve for a little while. You've gotten to a point where you're comfortable using it and that sort of thing. And so it feels kind of ubiquitous. It feels like it's everywhere. But I think in reality, what Tom was starting to say was that basically, we're really still pretty early in the process.
Yeah, I think that's definitely right. There's more to come on that, and it's going to ripple through everything. People will steal ownership of a home just by going to the local registrar and recording it. It's like, come on, folks, you didn't need blockchain to fix that problem. Check somebody's ID, for goodness sake. So, absolutely, a lot of legal work is I give a talk to lawyers, and I just gave it 6 weeks ago. It's just like, look, a lot of what we do is going to go away. You were replaced by the blockchain, and good riddance, in my opinion. So move on to something else, because it kind of had become mindless work. Title insurance, right?
Yeah. I actually was thinking about that as this conversation was unfolding. Is like, when you go and you look at, when you purchase a house, they didn't have to do due diligence on, chain of ownership and this and that, and something like blockchain could actually eliminate all of that headache that comes into play there. So it'd be interesting to see how blockchain will I can't even say it, revolutionize the real estate industry just based off of those things. So we're kind of getting to that time. Can you maybe tell our listeners where they can learn more about what you do and possibly reach out if they have questions?
Yeah, so I'm always on LinkedIn. My legal services practice is at kilpatricktownsend.com. So you can reach out there, just tfranklin at kilpatricktownsend.com, or at Triangle IP, it's just Tom at triangleip.com. Happy to have a conversation. It's funny, a lot of times, I'll talk to anybody for a half an hour to an hour. And often I'm trying to convince them that they don't need patents, or there's another way to go about doing it, or look at this and that, because it's so rare to have a vendor kind of try and talk you out. But I've had so many times where if you're raw about it from the get-go and it didn't make sense, it's, you're going to find out 3 weeks from now after you wasted a bunch of time. I only want to see my clients successful at this point. As I've achieved enough success in my life, and I don't have to work anymore if I don't want to. The thing that really gets me going is to see that next company make it to unicorn status, or to see somebody really successful, or things just blow up. That's what's fun to me. Because I'm doing it. I'm in the fun phase of my career where I only want to have fun, as I define it, is seeing other people create wealth and be successful, and filing another blockchain patent and somebody building an enterprise around it that hires a bunch of people and makes them wealthy. Nothing would make me happier. And by the way, I'm probably going to make a couple bucks along the way, but I'm always going to challenge you. And my rule is I'll push back twice. Is I'll try and talk you out of something twice, but then after that, it's yes, sir, it's yes, ma'am. I'll go about doing it, because the moral hazard always for me is I get paid by the hour. So if I don't push back, I feel as though ethically I may be choosing advice that only is important for my business model. But today, all I want to see is my client succeed. Nothing would make me happier. And if that's not happening, I'm just kind of not interested in representing you, even though it might be very lucrative for my business model. It's just not something I want to be involved in. Life's too short.
Yeah, no, I think that's right. And I think, to your points earlier about education and even some of the naivety we've expressed during the period of the show, it's clear that not everybody even really knows what they need, right? They're reaching out to you for, prospective advice or, I think I need a patent, but what I actually needed was a trademark or, whatever it is, right? So I think, your willingness to sort of take people on and at least hear what they've got to say and maybe steer them the right way is not only super ethical, but also just, super, I guess, appreciated for people, like me who might say, okay, well, I've got to patent this idea and, maybe spend a bunch of money or a bunch of time trying to figure that out when you could have just, consulted with me and we could have wrapped it up in an hour. So I really appreciate that about, your character and the way you do that. And then just also it's, really, I think a good way of doing business.
Well, Ryan, any closing thoughts?
Nope, I got nothing else. So Thomas, thanks so much for doing this. I really appreciate it. Like I said, I think you may be our only patent attorney that we've ever had on. So this is really useful information. I know I learned a few things. And so thanks so much for doing this. We appreciate you.
Yeah, it's been fun. Great bunch of questions.
Absolutely. And thanks so much to everybody who tunes into the show this week and every week. And we'll see you guys next time.